This Honorable Court of Criminal Appeals of Tennessee is now in session.
All right. Thank you, Madam Clerk. Good afternoon, everyone. This is the November session of the Tennessee Court of Criminal Appeals here in Nashville. We are obviously operating via Zoom until we can get back in the courtroom, which we hope will happen very soon. My colleagues this afternoon on the panel are Judge Robert Holloway from Columbia, Judge Ross Dyer from Memphis, and my name is Robert Wiedemeyer. 20 minutes per side for arguments, counsel. If the appellant wishes to reserve some time for rebuttal, feel free to tell me at the beginning and I'll try to help you keep up with your time. And keep in mind the fact that we have read your briefs, so we're familiar with the case to that extent. I think that's all the preliminaries I have. So, Ms. Lindsay, if you'll call the next case on the docket, please.
State of Tennessee versus Martin Riley III.
All right. Is this Mr. Pinson?
It is, Judge.
All right. You ready to argue?
Yes, Your Honor.
All right. You want any rebuttal time?
5 minutes, please.
Certainly. Go right ahead.
May it please the court. My name is Seth Pinson. I'm here today representing Mr. Martin Riley. I represented him all the way through the trial court, and I represent him up in the appellate court here today as well. What we're here today about is really a simple issue. I attempted to keep this brief as straightforward as I could because I wished not to take away from the gravity I think this issue deserves. We're here because the trial court declined and refused to give any instruction on a statutorily created defense to the felony or vehicular evading offense charge, or evading arrest charge. I think there are three reasons that this court needs to reverse the trial court's decision and grant Mr. Riley a new trial. The first is that the trial court's decision that the defense to the felony evading arrest charge does not essentially exist in Tennessee law is not supported by Tennessee law. There's simply no law to support the judge's ruling. The second is that not only is there no case law or statute on point that would allow the court to rule as it did, but the canons of statutory interpretation also clearly conflict with the ruling made by the trial court. And finally, and most simply, I believe that the defense was fairly raised at the trial level. So with that said, to start with, I do wish to point out, I understand that you've read my brief, but to be clear, we're here about a supposed conflict between the charging statute for felony or vehicular evading arrest, which says that, and I'm just going to read it here, it is unlawful for any person while operating a motor vehicle on any street, road, alley, or highway of this state to intentionally flee or attempt to elude any law enforcement officer, and here's the key part, after having received any signal from the officer to bring the vehicle to a stop. Immediately after that, the next section in the statute says it is a defense to prosecution under this subsection B that the attempted arrest was unlawful. And of course, both of these clauses are contained in the statute that criminal defense attorneys across the state and prosecutors alike refer to as evading arrest.
Let me ask you this.
Yes.
I understand the defense as it's written in the statute, but if there's a suppression motion before the trial and the trial judge finds that the stop is lawful, how do you raise the defense at trial? There's already been a legal determination that the stop is lawful.
I think that is correct as to suppression. However, I do not think, and I do not believe that there is any mechanism in the rules of criminal procedure that allow a judge to cut off a jury defense before proof is given. The way to do that is to allow proof to come in and for the trial judge to arrive at the conclusion after proof at trial, and I'll explain why in just a moment, that the defense is not fairly raised. Here's why.
Well, but there's other defenses. So if your client was trying to raise an insanity defense, we're going to have a pretrial hearing on whether or not the medical proof supports an insanity defense, and the trial judge makes a legal determination one way or the other, and either gives the insanity instruction or does not. You don't then get to put on proof at trial of an insanity defense and get to argue the defense. The trial court's already made that legal conclusion, do you?
I think that the procedure for that defense is specifically laid out and specifically set up, and I do not think it is applicable to this defense. Here's the reason that I think that's important. In suppression hearings, and in this suppression hearing, the one that happened in this case, the proof that I elicited there was different than the proof I elicited at trial. And there is no burden upon the defendant to prove before trial that he can properly raise the defense. There's just no burden on the defendant to do that. There's no requirement that the defendant do that. So it is properly a decision that can only be made after proof has been entered at trial. Now, in this case, the judge ruled before proof and after proof, and the rulings are consistent. They both say not that the signal to stop is not fairly raised, but that it can't be raised because there was no unlawful arrest. The judge has ruled here that a signal to stop is not an attempted arrest within the meaning of the statute. And so by saying that, he says this defense can never be raised. And to quote what he ruled here after proof, attempting to bulletproof his previous ruling, I believe, he said, "I don't see that it is fairly raised," referring to the defense, "or how it could possibly be fairly raised when an arrest is not any element or is not in any form or fashion an element of anything that's required to trigger the statute." What we're here about today is whether or not the signal to stop language in the charge is applicable to the defense. If it's not, then you're correct. I would lose. But the issue of whether or not the judge ruled on a suppression motion is not at issue on his interpretation of the statute, which is what's really at issue here.
Well, okay, but if I understood you correctly just now, he made two rulings. He said it wasn't raised by the proof, and then two, he says, I don't ever know if it ever could be raised by the proof. Well, if the only ruling we're really then looking at is, as far as your client is concerned, is whether or not it was fairly, if he made that first ruling, whether or not it was fairly raised by the proof, that's all we're here to look at, not whether or not it ever can be, correct?
That would be correct if that were the court's ruling. Respectfully, and I understand what the record shows, I've read it many times, and I understand the way that it's worded. What I would point this court's attention to is that this ruling was first made the day before trial during a conference call, and then I made sure to get it on the record during voir dire and actually asked the trial court not to rule until the close of proof, and he did anyway. This was not, to be clear, a ruling about the proof that it was elicited. It was a ruling about the statute, and we know that because the judge said that before any proof was entered. Now, moving to law that's at issue here, because I think this is very important. Tennessee law, to my knowledge, and I've looked for many hours, does not specifically rule. There's no case that specifically rules on this. But three cases that I've cited in my brief are very, very relevant, and all are in my favor. I'm referring to State versus Dowdy, State versus Whipple, and State versus Wiggins. In State versus Dowdy, the appellate court actually undertook probable cause analysis to decide whether or not the defense was fairly raised, which is exactly what I'm asking. I use reasonable suspicion because I believe that's the correct standard for a traffic stop. But I think it's very clear that an attempted or there is an unlawful arrest within the meaning of the defense when a signal to stop is given with insufficient legal basis, whatever that constitutional analysis is. In State versus Whipple, the court there said the record shows that Officer Sherrill testified that he had personal knowledge that the defendant was driving on a revoked license when he attempted to arrest the defendant. And they use that attempted to arrest the defendant in a situation where the only action taken by the officer was a blue light. The chase in that case was never actually concluded. And still the court referred to it as an attempted arrest. And then in State versus Wiggins, this court specifically said that we can't allow officers to turn their blue lights on behind people with no reason or not a good reason, and then pull them over and search because they didn't stop for the blue lights that were illegal in the first place. And that again, that's just what Wiggins says. That's not my opinion. That's what this court has previously stated. Now,
but so the other question I have is, what arrest is he evading? Because as I understand the facts, and again, we haven't read the record, we just read the briefs, he gets pulled over for a broken taillight. And there's a lot made about whether the taillight was broken or not, this, that, and the other. But he pulls over, he complies, everything's fine. The officer goes and runs his name and realizes he has a warrant or something like that. And as he comes back, that's when your client takes off. So what arrest is he evading? Because if it's the second one, all this other stuff really doesn't matter.
The answer to that is that the state never raised that argument at the trial level. The only signal to stop that we argued about was the blue light that led to the initial pullover. And I would submit that that blue light was continuing and there was no new signal to stop until Mr. Riley fled. So to the extent that he fled from the original signal because there was no new signal. The state has this is correctly stated in its brief that evading arrest is a continuous crime. And I think that has a different meaning and importance to this case than the state does, I believe. But my answer, Judge, is that the same signal was ongoing from the time Mr. Riley was originally blue lighted until he actually until he wrecked at the conclusion of the chase. It's all one signal. It's all one thing. Now, moving to some statutory construction concerns, because I don't want to gloss over them. I think that, well, obviously the first thing that we have to do is ascertain the legislature's intent here. And this was briefed extensively along with my proposed jury instruction, which we won't spend that much time on today. But I think it's very clear that the legislature's intent here is to do the same thing that our suppression hearings do. These cases typically involve suppression issues as well as this one did. And also the defense, the identical defense to misdemeanor evading arrest involves this same constitutional probable cause type of analysis. The rationale here is to keep law enforcement from taking action that they are not constitutionally allowed to take. The only way to do that with this statute is to interpret this unlawful arrest to encompass a signal to stop that is not supported by probable cause or reasonable suspicion as the constitutional analysis is required. Additionally to that, criminal statutes are to be construed giving fair import to their terms. That there just is no way around, in my opinion, this, Your Honors. We refer to this whole statute as evading arrest. That's how everybody refers to it. And it is bordering on problematic to act like there's not an attempted arrest just because it's a felony evading arrest or a vehicular evading arrest. We all think of these as attempted arrests, whether it's a blue light or not. And what the trial court has done here, what it said is that this is not true. And if that's the case, I can't think of any cases I've seen, whether they've been my cases or colleagues' cases, where a signal to stop has been given to a client that flees using a vehicle, and that signal was not given using a siren or blue lights or both. So to rule this way, that it's inapplicable to the elements of the crime will essentially mean, even though it doesn't have to be explicitly stated as such, that this defense can never be raised by any defendant across the state that's charged with vehicular evading. And because of that, it reads this clause out of the evading arrest statute, and that just doesn't comply with the canons of statutory construction that we're supposed to abide by, and that this court uses. We have to give meaning to the statute according to its normal usage, and in this case, we referred to a signal to stop in common terms as an attempted arrest. Going further, and this is going to backtrack a little bit, it's worth hitting again. I want to reiterate that in all of the record that there is, and in all of the conversations and hearings that we had in this matter, the only parameters within which the court ever ruled on this, there was never a ruling where the court mentioned that the signal to stop is good after the suppression hearing. And there he absolutely did that. And I think we've already addressed that issue. The ruling here is just that the statute containing the defense and the section containing the offense are mismatched and it can't be applied. That's what the court's ruling was here. And the fact that the court came back after proof and said it wasn't raised and it couldn't be raised, it doesn't change the fact that what the court was doing, and the only evidence in the record is that the court was ruling as it saw the mismatch between the elements of the offense and the elements or the language contained in the defense. To look specifically at two allegations that the state has in its brief that I think are worthy of note now as opposed to my rebuttal. The parole issue, my client was on parole. I filed a motion in limine to exclude that evidence. I have no idea if the state was going to pursue this avenue to say, as Your Honor mentioned earlier, Judge Dyer, that this stop occurred and then there was a new set of circumstances. If the state saw things that way, then I have no explanation for why they did not contest my motion in limine with regards to my client being on parole and say, he's on parole. We have all the rationale in the world we need for a stop. That never happened. That was never brought up by the state. That was never argued by the state. And I do not have a reason why it was not argued if the state was planning to pursue or attempting to pursue the avenue that Your Honor has mentioned. That just was not a part of this litigation. And not only that, it's not something that was in proof at trial. And so it's not something that can be weighed in viewing whether this defense was fairly raised. That parole issue and whether my client was on parole, the jury never heard that. The judge ruled before trial that evidence would not come in, and it was not in evidence. A ruling on whether a defense is fairly raised views the evidence in the light most favorable to the defendant. And I only have to get somewhere less than a preponderance of the evidence. None of that is in proof, and it can't even be weighed. So as far as the state's argument that the fact that my client was on parole makes this harmless or otherwise makes this defense inapplicable, I think that's incorrect. It wasn't in proof. It can't be weighed as a part of whether it was fairly raised by the proof or not. As far as the later offenses, the state did use this argument at the trial level, and there was considerable briefing of this issue of whether or not after my client fled, whether or not these traffic, fairly minor traffic incidents, not that they're not important, but compared to a felony, running a red light's just not going to have the punishment associated with it. Double jeopardy is going to be a very big problem, and that's the reason that I don't think those can form the basis for this felony charge. As the state said in its brief, and as we've already mentioned once today, Vehicular evading is a continuing crime. There is no election. The state doesn't have to say which set of circumstances it's relying on, because it's all one set of conduct. That is problematic when the beginning of that conduct is immunized. If this defense applies, it must immunize all of my client's liability only for evading arrest through the end of the chase. I am not saying, and I want to be very clear that I'm not saying that my client cannot be charged with any of these traffic infractions, or if my client had been charged, for instance, with vehicular assault, if he had wrecked during this. That is a different crime, and he could certainly be charged with that. But if my client is fleeing from an unlawful arrest and has the right to flee because of this defense, he cannot be charged with a different felony evading count while he is in flight from the original unlawful signal to stop. He can be charged with any of the conduct that he takes during that time, but not for evading arrest.
Mr. Pinson, you're getting into your rebuttal time. I just wanted to let you know you still got.
That's all that I have at this time, Judge. I think I've covered everything that I needed to in the body of my argument. Thank you.
All right, thank you. General Watkins, good afternoon. You ready?
Yes, Your Honor. May it please the court. Austin Watkins again, appearing on behalf of the state of Tennessee. Defendant asked this court to grant him a new trial because the trial court declined to give the jury instruction on statutory defense of felony evading arrest. However, the court need not address this novel issue of statutory interpretation because the record readily shows that the defense was not fairly raised by the proof. And as a result, the defendant was not entitled to the jury instruction, and the judgment should be affirmed. Your Honor, the facts are pretty simple in this case. Police officer saw the defendant driving past him and thought he saw a taillight violation, so he initiated a traffic stop. During the course of the traffic stop, he discovered an outstanding parole violation, and when he returned to the defendant's vehicle and asked him to step out, the defendant peeled it out and took off and committed about half a dozen traffic violations, fled through a residential part of Cookville. And so based on that, Your Honors, admittedly, there is an interesting issue in what's the proper interpretation of this statute regarding felony evading arrest and what is clearly a defense to that offense. However, the court, even though the trial court initially had a broad holding that basically was, as described by the appellant, that the mismatch in the language in the offense and the defense are so incongruent that this defense can never be raised under basically any factual circumstances, the court then back at trial put on the record, you know what, even if there was a way to raise this, this defense, it wasn't raised by the proof here. And specifically, the court, talked about how in Tennessee, I think the court's phrase was, you can't get your murder for free. And so, Your Honor, we cited two different cases that provide two separate means by which there was a lawful signal to stop that the defendant failed. As Judge Dyer pointed out, he did the initial blue lighting when he pulled over to the side of the road and allowed the officer to request his registration and driver's license and kind of start through what is a normal traffic stop. However, after that, there became not just the basis for investigating this taillight violation, there became an independent basis, not just to investigate, but to arrest him for a parole violation when that was discovered through the officers kind of checking for warrants. And then you have a separate basis for all of these other traffic offenses. Supreme Court of the United States in Utah versus Street has held, it's a different legal context, but it's almost identical facts, says if there is a traffic stop, regardless of the legality of the initial stop, if an officer discovers an outstanding warrant, that in and of itself is a separate lawful basis to then arrest that defendant and does not require any suppression of the evidence. And so that is what happened here. I mean, the officer found that, he testified to it at the suppression hearing. The defendant is on the record as attorney, conceding that parole violation exists. And so that in and of itself shows that there was no way he could raise this defense, because when he took off in light of that probable cause to arrest him on that warrant, he committed felony evading arrest. And that means this court doesn't need to step back and then look at the original stop based on this alleged, whether there was a taillight violation or not. And then
let me ask you the same question, maybe phrased a little different, that I asked defense counsel, and that is, if there is a suppression hearing regarding a traffic stop, and the trial court finds, yes, the officer had reasonable suspicion, probable cause, whatever you want to say, to make the stop, and then how can we then come back later and say the stop was unlawful? And let me add to it. Let's say that let's say it's a DUI case, alleged DUI case, and the officer thought he saw the guy cross the center line and thought he was drunk, pulls him over. He does field sobriety. He does a breathalyzer, and the guy, he blows .00. I mean, he is sober as a priest. Doesn't make the stop unlawful, does it?
No, Your Honor. And I think my understanding kind of the question you asked to appellant's counsel, and then in conjunction with this issue, was kind of, can it be that the statutory defense is really asking the jury to essentially reconsider the suppression issue, right? If you've got a trial court who says, this is a good stop, there's no constitutional problem, I believe this officer, did the General Assembly intend for this defense to mean that the jury had to reconsider the credibility of the officer and redetermine whether there was either reasonable suspicion or probable cause? And Your Honor, when I prepared to file the state's brief in this case, we talked about that. And even though it is uncommon for that to be true, there are other situations in which that is what the statute requires. So, for example, there are defenses that require a jury to make a legal determination regarding reasonable suspicion or probable cause. For example, with the defense regarding handgun possession, a jury may be asked to determine, or these self-defense instructions, whether or not the defendant was kind of using a certain amount of force or was acting lawfully at a certain time. Well, those tend to seem like not the factual issues we usually would expect the jury to be making. But I think, Your Honors, the fact that the statutory language here is, it is a defense to prosecution under this subsection, that is consistent with when the General Assembly intends there to be a general defense that a jury has to consider. And so, I do think, Your Honor, that what essentially you would be looking at, to your specific hypothetical, you could have a trial court go, the Constitution does not require suppression of this because there was no constitutional problem under the Fourth Amendment. However, because that separate statute exists, we're going to have to let the jury decide whether or not it disagrees. And that is something that would be within the prerogative of the General Assembly to create as a defense to an offense that it is also created, if that makes sense. So, Your Honor, the state would agree that it seems a little unusual that would be the question that would be presented to the jury. But frankly, Your Honor, that does appear to be what we've got here. And this language would be consistent with this process of once the defendant clears this hurdle of more than slight evidence, but not necessarily a preponderance of the evidence, that if the inferences are drawn in his favor, that a defense could apply, the state then has the burden for a general defense to disprove it beyond a reasonable doubt. That's the way the defenses work under Tennessee law. And this appears to be one of those situations, Your Honor. And I think maybe to make it make a little more sense, I could see a situation where if you had, for example, hypothetically, an unsavory prosecutor where the prosecution lost the suppression hearing and the evidence from the stop is suppressed. In this case, for example, there wasn't just an evading arrest charge, there were drug charges. Now, the defense was acquitted on the judge charges, but the suppression application of the exclusionary rule only applies to that physical evidence. So the state could lose and the evidence would be suppressed, but it would go, hey, you still ran from us. We're going to prosecute you for fleeing. Well, I don't know that there's a constitutional basis to suppress the arrest or suppress that criminal conduct, if that makes sense. And so this is kind of giving an extra added level of, look, if the police messed up and they shouldn't have been trying to investigate you anyway, then it makes sense that the jury would be able to come back and kind of vindicate the defendant in that instance. And so does that kind of speak to your concern there, Judge Dyer? Yeah,
it does. It does.
Okay. So I say that recognizing that I think, frankly, the defendant proposed a very reasonable special jury instruction based on a reasonable interpretation of this statute. However, there will be a case maybe one day where this court will need to decide what the language is supposed to be. Does it really require an actual attempted arrest, or is attempted arrest as used in the statute, is it just synonymous with, an investigatory stop, a signal to stop? But this court doesn't need to do that in this case. The fact.
Let me ask, and I've read this statute now, it's short, several times, and I still don't quite understand it. And I guess what throws me off is the fact that he received a signal to stop and he stopped. And I'm trying to figure out how that then plays into the later events where the guy now who has stopped based on a signal to stop then flees. How does that figure into this statute, General?
Your Honor, the state's position is that it just doesn't. When he actually fled was when he peeled off. And there, at that point, the officer at the time was thinking taillight investigation. But I also know that there's an outstanding parole violation. So he just thinks when this guy runs, I've got two different bases to stop him. This is a lawful investigation. The problem is even if you assume that the initial stop was lawful, you can even assume that the officer knew there was no taillight violation, was purely making up a basis to pull the defendant over. Once he's in the middle of the traffic stop and finds out, there is a warrant that is out there that any officer who sees this defendant has an order, is how Streif interprets the warrant, as a judicial command to arrest upon sight, essentially. Because probable cause has already been determined by a magistrate, then that is the lawful basis there. And so, they're kind of separate issues here, but I think the reality is while the defendant's raised a good issue for some defendant, for some case, it just is not an issue here, because regardless of that initial stop, the fact that he fled once there was a undisputed basis for him to not just be investigated, but be arrested based on that warrant. And then he started committing all these separate offenses where as long as that blue light's going and he's committing crimes and the officer continues to gain more and more reasons to leave those blue lights going to pull him over, that's where it is relevant that this is a continuing offense. That is all the same felony evading arrest. The state can't turn around and go, hey, you fled from the original traffic stop. That's one felony evading arrest. Then you fled from the parole violation. That's a second one. And then you committed these traffic offenses. It's a separate felony evading arrest for each one of those. That's just not how it works. It's one evading arrest. And so the Abernathy case, Your Honors, that we cited in our brief is very clear on this. I mean, the court, it's a published opinion. It says a new distinct crime, even if triggered by an illegal stop, is a sufficient intervening event to provide independent grounds for an arrest. And that was not, a felony evading arrest case, but it was a unlawful search warrant that during the execution of the search warrant, the defendant was trying to, flush drugs down the toilet, and the state and this court held, you can't sit there and challenge the validity of the search warrant and then get away with tampering with evidence. Those are two separate issues. So the suppression may be geared at what the initial stop was based on, but when you've got these subsequent offenses, there's a lawful basis for a stop. And so for our purposes here, when we look at the statute, was there, even in the defendant's, drawing all the inferences in his favor, did the facts ever raise this proof, fairly raise this defense? It didn't, because he can't dispute that he could have been arrested on the warrant, and then he could have been stopped and cited, based on those traffic violations. And so he's just kind of stuck with that. That maybe if, for example, we didn't have the parole violation and we didn't have subsequent traffic offenses, if the officer blue lighted him and he never stopped, he didn't commit any traffic offenses other than, that initial taillight violation, and he drove all the way home. And that's when the officer, stopped him and searched his vehicle. Well, then that would be a different case. I mean, that would be a different case where his argument that, hey, the officer was lying about the taillight violation, and that's all that he's got to go off of. And I can point to these inconsistencies in his testimony that show that maybe a jury could have chosen not to, accredit that stop. That's a different case. That's a different case, Your Honor.
Let me ask you, let me change the facts and hypothetical a little bit.
All right.
So officer pulls him over for the cracked tail light. Officer goes back to his patrol car, calls in the license. Dispatch says, hey, look, we got a backlog. It may take us 20 minutes to get you this information. The officer says, well, whatever. Goes back up, hands the defendant his license and says, go on. As the officer's getting back in his car, dispatch calls and says, oh, by the way, there's 2 outstanding warrants for that individual. Okay. He can still see the car. Officer throws on his blue lights, gets behind him, and defendant doesn't stop. Does the defense come into play? Because now, I mean, there's clearly an intervening circumstance at that point, I guess, is what I'm trying to make that distinction. I mean, we can argue all day long that, hey, he testified about this, about the light, and then about that, about the light. But there's no question the dispatch came back later and said he's got an outstanding warrant. Is that enough to break the chain from the first stop to now create a second stop? Is my question making sense?
I believe so. Your Honor, safe position is yes, absolutely. That your hypothetical is even a cleaner case than kind of what we've got here. And I guess to focus in on really the issue is the state understands the defense to be, we don't want a defendant to be essentially guilty of a crime of failing to stop when he never should have been asked to stop. So if at any point the state can identify a lawful basis on which he should have stopped and was subject to investigation or arrest, then that is when there is a felony evading offense. And now if there's a factual dispute that would raise a defense, where you'd have to isolate one particular basis was at issue, and there was conflicting proof where a jury could choose to believe one set of facts or the other, and it needed to determine that, okay. But in a situation where there is one uncontested or multiple uncontested bases upon which at any time a blue light was flipped, the defendant should have stopped and yielded to that show of authority, and he didn't, then that is the offense, okay? And so in your situation, Your Honor, with that second kind of, I told him to go, and then I decided, I got my subsequent basis now, and I'm blue lighting again, the defendant needs to stop. As a defendant, a citizen needs to yield to every blue lighting that comes, And so if he drives all the way home going, I think that he told me I could go. I don't know why he's driving, for a mile or 2 or 3 and still trying to flash his lights at me. We want that person to stop. Now, if the officer is abusing his authority, didn't have a basis for that second stop, well, that's where the defense comes in, Your Honor. And so I hope that that's clear enough that even though this is kind of a messy situation and there is, again, an admittedly interesting statutory interpretation question for kind of how this statute works, I think there are reasonable ways in which it would work. There's a reasonable rationale for why the General Assembly intended for this offense to be set forth the way it is, and for why the defense is set forth the way it is. But under this particular set of facts, the defendant unfortunately just can't avail himself of any problem with the drafting in the statute, because he was supposed to be arrested, and he can't just choose to take off and then commit numerous offenses when at any given point the officer can keep requesting him to stop based on each traffic offense that he's committing as he's running from the first stop. And that is clearly established in the case law. That is Abernathy, Your Honors. And so if there are any more questions, I'm happy to continue to kind of engage. And frankly, it's been interesting, Your Honors. But the state is confident that if you really look at the facts and look at the arguments, you just don't need to get into this tricky statutory interpretation question in this case. And so based on that, the trial court's alternative ruling that the facts did not support a fair raising of this issue to go to a jury, where there should have been a jury instruction for the jury to consider whether or not the stop was unlawful. It wasn't there. There wasn't a fair basis for that defense to be raised, and we'd ask you to affirm, Your Honors.
Thank you, General. Mr. Pinson, you've got your rebuttal time.
Thank you, Judge. I want to almost pick up where that left off, and I want to first talk about the parole violation one more time. I want to be clear in the hypothetical that you posed to opposing counsel. I think that my client would not have a valid defense there. If he was told he could leave and then the officer had a valid parole violation that he was told of then, I don't think we would have this case. That's not what we have. What we have is a situation where my client was giving a continuing signal to stop, and that's just where we are. Now, as far as the subsequent, and more importantly, the parole violation was not in proof at trial. The state waived that. They didn't even contest my motion. More importantly, on the subsequent violations or subsequent crimes, I disagree pointedly with the idea that if my client is fleeing from an invalid blue light, that every crime along the way that he commits provides a new felony evading crime. That cannot be the way this defense is meant to operate or could operate. It is a continuing crime. That means if my client is fleeing from an unlawful signal to stop, his fleeing is immunized, not just at the moment he begins to flee, but his entire flight. That is not to say that crimes he commits while fleeing are immunized or okay. That's why I gave my negligent homicide or my vehicular homicide example. He can absolutely be charged with failing to yield or failing to stop at a stop sign. But if his flight is immunized, if his flight has a defense that is applicable to it, he can flee for as long and as far as he wants and cannot be charged with felony evading. He can only be charged with the crimes that he committed. Otherwise, how could this defense ever actually operate? Because there is one notable exception that I know of, and you'll all think of the OJ chase, if we want to call it a chase, where he just kind of put down the road and maybe didn't cause any traffic violations. But outside of a situation like that, if a subsequent traffic infraction allows for a new felony evading charge, there will never be a defense that is practically raised. And for a deeper discussion of that, I provided one in my brief that was submitted along with my proposed jury instruction. It appears to me, Your Honors, that really the state and I do not disagree on, except for a few points, meaning subsequent offenses, the parole situation, which just was not in proof and cannot form the basis of a valid reason for a stop or for harmless error in this case, because it wasn't provided by the state at trial. And then, of course, the nature of the court's ruling, which I truly believe can only be characterized as a ruling on the statute and not on the proof with relation to a signal to stop. But those are the issues that I think the court needs to rule on, and I have no further argument.
All right. I think that concludes this case. Mr. Pinson and General Watkins, both of you made excellent arguments and wrote excellent briefs, and we appreciate that. And we'll get to this case, we'll take it under advisement and get an opinion out as soon as possible. All right. Nothing further. We'll be in recess, Madam Clerk, until the next case. Thank you.
Thank you.
This Honorable Court of Criminal Appeals of Tennessee is in recess until 3 p.m.